Subcommittee on the Constitution and Civil Justice will come to order. Without objection, the Chair is authorized to declare recess as the committee at any time. We've called this hearing to examine the continuing need for Congress to pass the Private Property Rights Protection Act. This legislation is needed to blunt the negative impact of the Supreme Court's decision in Kelo versus City of New London, which permits the use of eminent domain to take property from homeowners and small businesses and transfer it to others for private economic development. In Justice O'Connor's words, the Kelo decision pronounced that, quote, under the banner of economic development, all private property is now vulnerable to be taken and transferred to another private owner, so long as it might be upgraded. Nothing is to prevent a state from replacing any Motel 6 with a Ritz-Carlton, any home with a shopping center, or any farm with a factory. The Kelo decision was resoundingly criticized from across all quarters. In 2005, the House voted to express grave disapproval of the decision and overwhelmingly passed the Private Property Rights Protection Act, with 376 members voting in favor and only 38 members voting against. Last Congress, the House once again passed this legislation, this time by voice vote. Unfortunately, the bill has not been taken up by the Senate. The Private Property Rights Protection Act prohibits states and localities that receive federal economic development funds from using eminent domain to take private property for economic development purposes. States and localities that use eminent domain for private economic development are ineligible to receive federal economic development funds for 2 fiscal years. Every day, local governments in search of more lucrative tax bases take property from homeowners, small businesses, churches, and farmers and give it to large corporations for private redevelopment. And federal law currently allows federal funds to be used to support such condemnations, encouraging this abuse nationwide. This bill will restore Americans' faith in their ability to build, own, and keep their property without fear that the government will take it and give it to someone else. And it will tell commercial developers that they should seek to obtain property through private negotiation, not by government force. Too many Americans have lost homes and small businesses to eminent domain abuse, forced to watch as private developers replace them with luxury condominiums and other, quote, upscale uses. Family farms have been wiped out by eminent domain to make way for shopping centers and big box stores. And churches generally entitled to tax-exempt status are often seized through eminent domain to be replaced by more lucrative private development. Unfortunately, it is usually the most vulnerable who suffer from economic development takings. As Justice Thomas observed in his dissenting opinion in Kelo, quote, extending the concept of public purpose to encompass any economically beneficial goal guarantees that these losses will fall disproportionately on poor communities. Those communities are not only systematically less likely to put their lands to the highest and best social use, but are also the least politically powerful. The deferential standard this Court has adopted for the Public Use Clause encourages these citizens with disproportionate influence and power in the political process, including large corporations and development firms, to victimize the weak. I am pleased this week that Mr. Sensenbrenner and Ms. Waters introduced again the Private Property Rights Protection Act. We must restore the private rights protections that were erased from the Constitution by the Kelo decision. John Adams wrote over 200 years ago that, quote, property must be secured or liberty cannot exist, close quote. As long as the specter of condemnation hangs over all property, our liberty is threatened. Let me now introduce our witnesses. I welcome you all here today, along with those welcome that you've already received. Susette Kelo purchased and lovingly restored her dream home in 1997, a little pink house with views of the water in New London, Connecticut. Tragically, the city of New London turned her dream home into a nightmare. Ms. Kelo was the lead plaintiff in the landmark Supreme Court case, Kelo versus City of New London. In that case, the court ruled that the city could take her home and give it to a private developer for economic development purposes. Sadly, Ms. Kelo's story is all too familiar with many other Americans trying to save their private property from governmental seizure. David, is it Beito, sir? David Beito is a historian and professor of history at the University of Alabama. His research focuses on civil rights history. Dr. Beito is the author of 3 books and has also written numerous scholarly articles. In 2007, Dr. Beito was appointed to the chair of the Alabama State Advisory Committee of the U.S. Commission on Civil Rights. As chair, he has addressed eminent domain abuse as a civil rights issue. Julia Trigg Crawford manages a 600-acre farm in northeast Texas that has been in her family since 1948. Ms. Crawford is fighting the use of eminent domain to take a portion of her family's farm as part of the Keystone Pipeline project. Her case is currently before the Texas Sixth Circuit Court of Appeals. Ms. Crawford is challenging TransCanada's authority under Texas law to exercise the power of eminent domain. Scott Bullock is a senior attorney at the Institute for Justice, Scott, a nonprofit public interest firm that represents people whose rights are being violated by the government. Since this time, with the Institute for Justice, Mr. Bullock has brought numerous cases in which homes or small businesses have been seized by the government through the power of eminent domain and transferred to another private party. In 2005, he argued Kelo versus City of New London before the United States Supreme Court. It is the tradition of the subcommittee that they be sworn. So if you'd please stand to be sworn. Do you solemnly swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? You may be seated. Let the record reflect that the witnesses answered in the affirmative. I now recognize our first witnesses. Please turn on your microphone, Ms. Kelo, before you speak.
I want to thank Representative Waters and Sensenbrenner for their sponsorship of the Private Property Rights Protection Act and for their support of property owners and tenants nationwide. My name is Susette Kelo, and I'm the Kelo in Kelo versus the City of New London, the case in which the United States Supreme Court ruled that private property, including my home, could be taken by another private party whose promises to create more jobs and taxes with the land. While we homeowners of New London may have lost that battle, we are winning the war. The decision sparked a nationwide revolt against eminent domain abuse and demonstrated that virtually the entire country, regardless of background or political party, is against this practice. But Congress has so far refused to join the rest of the nation in Kelo backlash and continues to fund eminent domain abuse. My 9-year battle began in 1997 when I searched all over New London for a house and finally found a perfect Victorian cottage with beautiful views of the water. I knew when I first entered it that I was meant to be there. My husband and I spent every spare moment fixing it up and creating the kind of home we had always dreamed of. And I painted it salmon pink, my favorite color. When I first bought the house, it had been run down. When finished, we made it beautiful. But the New London Development Corporation decided it wanted to give my property to a private developer. So it told my neighbors and me we had to sell or be condemned. But we all loved our homes and neighborhood, and we were not prepared to give in. 9 years later, the United States Supreme Court ruled against us. My story is not unique. In just the year after the decision, almost 6,000 homes and businesses were threatened or condemned for private development. And just as my neighbors and I didn't want to sell and didn't ask to be condemned, neither did the hard-working, tax-paying Americans fighting to keep their homes and businesses. Congress must stop funding this abuse of power. Our federal tax dollars shouldn't be used to take away our homes and businesses so that developers can build shopping malls, high-priced condominiums. The project that was supposed to replace my New London home in New London received $2 million in funds from the Federal Economic Development Administration. If this bill that had been in place, it could have helped prevent New London from seizing my little pink cottage, which my husband and I spent years making into the kind of home we could be proud of. And all of this was for nothing. After spending close to $80 million in taxpayer money, there has been no construction whatsoever in the neighborhood. To this day remains a barren field, home to weeds and feral cats. And in 2009, Pfizer, the linchpin of the plan, announced that it was closing its research and development headquarters and leaving New London for good. My battle started as a way for me to save my home. But it has rightfully grown into something much larger. The fight to restore the American dream and sacredness and security of each one of our homes. Property owners across the nation are now up in arms and united in the fight to end an eminent domain abuse. I thank Representative Waters and Sensenbrenner for being on the front lines, and I ask Congress to join them by passing the Property Rights Protection Act. Thank you.
Mr. Kelo, thank you very much. Dr. Beito.
Thank you
Yes, sir.
for this opportunity to come here today and speak on this issue. My focus is going to be on how expansive eminent domain to benefit private interests as a consequence of subsidizing private development has posed and continues to pose a threat to the civil rights of minorities and the poor. In my view, the Private Property Rights Protection Act of 2013 provides the best available means to provide some measure of corrective relief. In the history of the United States during the last 100 years, no group has suffered more from eminent domain abuse than African Americans. According to one typical study, 2/3 of those displaced by urban renewal, often via eminent domain, were non-white. Another study found that 4/5 of these paid substantially higher rents than they had before. Commenting on the fact that government-sponsored urban renewal destroyed far more housing units than it ever replaced, author James Baldwin charged that urban renewal means moving the Negroes out. It means Negro removal. The federal government is an accomplice. The pattern of abuse did not end in the 1960s and 1970s. It has often continued to the present. San Jose, California, for example, 95% of the businesses in recent years destroyed by eminent domain were minority-owned, even though they constituted only 30% of the businesses in the city. In 2005, this long record of eminent domain overreach prompted several important minority organizations, including the NAACP and the Southern Christian Leadership Conference, to jointly file an amicus brief for the plaintiffs in the Kelo case. After reviewing the historical background, this brief warned that enabling local governments to, quote, take property simply by asserting that they can put the property to a higher use will systematically sanction transfers from those with less resources to those with more. Even absent illicit motives, eminent domain has affected and will disproportionately affect racial and ethnic minorities, the elderly and economically disadvantaged. Well cared for properties owned by minority and elderly residents have repeatedly been taken so that private enterprise could construct superstores, casinos, hotels, and office parks. It might be asked why Congress needs to step in now. Can't the states be trusted to prevent the abuse of eminent domain? Unfortunately, the 8-year aftermath of Kelo shows that they all too often will not, especially when federal money is potentially at stake. My own state of Alabama is a case in point. In the wake of the national outrage over Kelo, it was one of the first to enact corrective reform. It greatly limited eminent domain for private purposes. Only last month, however, Alabama reversed course and gutted a key element of this reform. Now, while some who have voted for it have since stated that they do not intend to undermine the earlier reform and even acknowledge the need to close inadvertent loopholes in the new law's wording, they have made no apparent effort to do so. If the states will not act to defend property rights of the poor and vulnerable, Congress must. As generations of civil rights champions have stressed, the protection of the right to acquire and hold property is critical to the economic progress of the poor and oppressed. 1849, for example, Frederick Douglass declared that the chief end of civil government is to protect the weak against the strong, the oppressed against the oppressor, the few against the many, and to secure the humblest subjects in the full possession of his rights of person and property. During a time of recession, it is all the more important to heed Douglass's timeless words. In the same spirit, it is also past due to start viewing the existing property owners in lower income neighborhoods as assets to the community. The passage of the Private Property Rights Protection Act of 2013 will greatly contribute to this goal by fostering an environment which will treat low-income property owners and entrepreneurs as valuable urban pioneers rather than as obstacles to be pushed out of the way if their rights conflict with some broader governmental or private agenda. Thank you.
Thank you, sir. Ms. Crawford, you're recognized now for 5 minutes.
Good morning. My name is Julia Trigg Crawford, and I manage the Texas farm my grandfather bought in 1948. Our land was taken by TransCanada for the Keystone Project, so I absolutely support measures to limit eminent domain. But I strongly oppose an exemption for TransCanada, Keystone XL, and any other entity that cannot provide proof their projects are for the public benefit. TransCanada abused the right of eminent domain in taking our land as it was the elbow they so desperately needed to avoid nearby wetlands, waterways, and pipelines. We never wanted them on our place to start with and told them so in 2008. We asked them to find another route through a willing neighbor just a little further west. They refused. We told them we wanted to protect the 1,000-year-old Caddo Indian relics on our farm. TransCanada's archaeologists recently found 145 artifacts within the proposed easement, some as large as silver dollars, yet their report discounts their merit. How curious that TransCanada and the Texas Historical Commission concur that my entire 30-acre pasture qualifies for National Registry of Historic Places except for the one sliver of land that TransCanada must have to connect the 2 sections of pipe already built. We told them we feared for Bodart Creek. Water is a farmer's lifeblood, and pipelines leak, and we didn't want to be a guinea pig for how to clean up tar sand spills in Texas waters. TransCanada said they're coming anyway. But more than anything else, we do not believe a foreign corporation transporting a product produced outside of Texas meets our state's qualifications of common carrier. No common carrier, no eminent domain. But TransCanada moved ahead anyway, exploiting Texas's flawed permitting process, and starts construction on my land tomorrow. But we are pushing back. The 2011 Texas Supreme Court ruling in Denbury Green said that private property rights are too precious to be taken by simply checking a box on a form. They also said, when challenged by a landowner, the pipeline has the burden to present reasonable proof it meets the requirements of a common carrier. So we asked for the proof. And TransCanada hid behind the skirts of the Texas Railroad Commission, an entity that fully admits they rubber stamp every application they receive. So we asked again for their tariff schedule. TransCanada said they could not have that tariff schedule until about the time product started flowing, meaning they could not produce the proof they could take my land until after they took my land, constructed a pipeline, and tar sands were about to flow. These examples of abuse are why TransCanada and the Keystone XL must not be granted an extension, and is why I cannot support this bill in its entirety. If we allow these exemptions, we'll be setting a dangerous precedent, leaving the door open for further misuse of our legal system and abuse of landowners. The same system that enabled a judge to rule against us with a 15-word ruling sent from his iPhone would enable TransCanada and other pipeline companies to use this incredible legal and psychological leverage of eminent domain to continue stealing property from American citizens. We have appealed to the Sixth Circuit, and if our funds hold out, we'll take it to the Texas Supreme Court. My family and I are standing tall for what we believe. I have not seen one shred of documentation that proves that one single drop of the products in Keystone's pipeline will wind up in my gas tank, or yours for that matter. Yet we are supposed to relinquish our family's tradition and the cultural heritage of the Caddo and endanger my land and water just because TransCanada says, without proof, that their pipeline is for the public good. How can this pipeline be for the public good when so much information about it is not even in the public record? Diluted bitumen, tar sands, whatever you want to call it, is a product we should fully understand before we start pumping it through waterways. TransCanada has called this product proprietary, refusing to provide specifics. How can we ensure the safety of a substance when we don't even know its ingredients? Pipeline companies do not deserve a free ride, especially when they can't clean up their own messes. Look at Enbridge in Michigan or Exxon in Arkansas, a spill I went to see for myself. The thought of that kind of destruction on my farm in my creek is frightening. America already subsidizes the oil industry at a monumental disproportion to other industries. Why should we further underwrite pipelines with our safety, our security, and our dignity? This bill, with its exemption of TransCanada and the Keystone XL, turns a blind eye to the most flagrant abuser of eminent domain today. Hold everyone to the same standards, and let those who manipulate the system for their own good suffer the consequences. TransCanada stole land that has been in my family for 6 decades for a project that will line their pockets. To allow them to walk away from past abuses without penalty is unforgivable. I will continue to fight these injustices because life as we know it depends on it, and I am not alone. Thank you.
Thank you, Ms. Crawford. And now, Mr. Bullock, I recognize you, sir.
Thank you, Mr. Chairman. Thank you for the opportunity to testify regarding eminent domain abuse, an important issue that has received significant national attention as the result of, as one of the members just recently pointed out, one of the nearly universally despised Supreme Court decisions, certainly in recent memory. And this committee is to be commended for responding to the American people by continuing to examine this misuse of government power, and it is our hope that Congress passes the Private Property Rights Protection Act. I did have the great honor of representing Susette Kelo and the other homeowners in New London and many other home and small business owners throughout the country that have been fighting this combination of public power and private gain. The Kelo case signaled that the U.S. Constitution provides very little protection for private property rights of Americans faced with eminent domain abuse. And indeed, the court ruled that it is acceptable to use the power of eminent domain where there is a mere possibility that something could make more money than the homes or small businesses that currently occupy the land. The Supreme Court has so far refused to reconsider the Kelo decision, just this week turning down another case that would have permitted the court to reconsider its misguided ruling in Kelo. Because of this threat has been noted by several people who have testified and by members of this subcommittee, there has been considerable public outcry against the closely divided Supreme Court decision. Organizations spanning the political spectrum have united in opposition to eminent domain abuse. Unfortunately, while several bills have been introduced in Congress, including one in the 109th Congress that passed the House by a vote of 376 to 38, Congress has yet to pass this legislation. The Private Property Rights Protection Act introduced in this Congress is common sense legislation that will stop the federal government from being complicit in an abuse of power already deemed intolerable by most individuals. It should be noted that eminent domain abuse was a problem before the Kelo decision, and it remains a problem today. We noted in the study that we released in 2003 that there were over 10,000 instances of private-to-private transfers of property in a mere 5-year period. And that is certainly an undercount of the number of times that eminent domain abuse occurs. In my written testimony, we've documented several instances of eminent domain abuse that occurred, including several instances both before the Kelo decision and after the Kelo decision where these projects received federal funds for this. As mentioned above, heeding a deafening public outcry against eminent domain abuse, 44 states have reformed their eminent domain laws in the wake of Kelo. These reforms vary greatly. Indeed, no two states enacted the same legislative reforms, but eminent domain abuse has become virtually non-existent in some states, while in others there remains serious abuse and much need for improvement. As Professor Beito just recently noted, Alabama passed legislation to roll back its eminent domain reform after being the first state to react legislatively to give its citizens stronger protection against this abuse of power. This demonstrates an ongoing need to remain vigilant against the fight against eminent domain abuse, and for this Congress to act in order to not give federal sanction to these abuses of private property rights. The legislation also contains important protections in order to preserve communities' ability, for instance, to deal with truly blighted properties that are abandoned, properties that pose direct threats to public health and safety. That is protected. It should also be noted that this bill will not interfere with communities' abilities to engage in economic development. Thankfully, most development occurs in this country without the use of eminent domain. And these reforms and the reforms that have been passed by the states do not interfere with the ability of private property owners to sit down, negotiate, and engage in economic development projects. In this economy especially, Congress does not need to be spending scarce economic development funds for projects that not only abuse eminent domain and strip hardworking, tax-paying home and small business owners of their constitutional rights, but in many instances, these projects fail. The project in New London, as Ms. Kelo mentioned, is Exhibit A in what happens when governments abuse eminent domain and engage in massive corporate welfare. After $80 million being spent, over 12 years since the redevelopment plan has passed, over 6 or 7 years since Mrs. Kelo and her neighbors were forced to out of their homes, there remains no economic development in this peninsula whatsoever, and it is a barren field. That is oftentimes too often the legacy left behind this abuse of eminent domain. So we ask this Congress to pass the Private Property Rights Protection Act to protect homeowners like Ms. Kelo and small business owners throughout the country. Thank you very much.
And thank you, Mr. Bullock. Thank you all for your testimony, and we will now proceed on the 5-minute rule with questions, and I will begin by recognizing myself for 5 minutes. And Ms. Kelo, I'll begin with you, and let me add my own special expression of gratitude to you for being here and for all the things that you did to get here. Mrs. Kelo, you were provided monetary compensation for the property that the city of New London took from you, but could you explain the emotional and sentimental costs that losing your home inflicted, costs that money simply doesn't compensate for?
Oh, correctly said. It really didn't matter what they gave us. We did not want to leave our homes, all of us. And it was never about the money, and we never talked about money. We never engaged in money conversations until the end when we were forced to do so after we had no choice and knew that we had to go. But we had one family that was there since 1890s, and what they did to us was absolutely horrible. Nobody in this country should have to live the way we lived. Nobody in this country should have to live the way we lived and lose what we lost.
Yes. Well, thank you. Mr. Bullock, let me ask you, this legislation takes federal economic development funds away from local government that violates private property rights for a period of 2 years. Some have argued that this removal of these funds is unnecessary and that the right of private action would be sufficient. Could you explain why, from an enforcement perspective, that taking away federal economic development funds is an important component of the legislation?
Well, it would provide a very strong incentive for local communities to not engage in these types of abuses. It should be noted that this bill would not override the substantive rights that would still be given to private property owners to fight against takings of property. So this is not a bill that tries to impose some type of federal standard of substantive rights into the court procedures that occur. So property owners would still, hopefully, if their state has passed good eminent domain legislation, would have the ability to fight the takings itself. What this bill, I think, really aims at is to try to persuade communities that engage in economic development to not abuse eminent domain in the first instance. If they don't abuse eminent domain, if they're not taking people's property against their will for private development projects, then there would be no effect upon those federal economic development funds.
Let me continue with you. It's very unfortunate that some of Miss Crawford's land is being taken to build the Keystone Pipeline. However, it's my understanding that unlike the economic development taking in Kelo, that using eminent domain to take land to build a pipeline has traditionally been accepted to be a public use. Is using eminent domain for building a pipeline or any other public utility, it projects a traditional pre-Kelo use of the eminent domain power. Can you give us some contrast?
Sure. That is something that Justice Thomas, in his dissent in Kelo, went through very carefully in looking at the history of eminent domain and in giving examples of how eminent domain is being used. And he noted, and of course he took the most restrictive definition of eminent domain possible. He really dissented alone, and he noted that common carriers and utilities have typically been granted eminent domain power to carry out those public uses. So that is quite different from the government taking land directly from one private property owner and handing it over to another private property owner that is not in any way a common carrier, has a special status under the law, but is just a garden variety developer, whether it's a condominium developer, a big box retail developer, a creator of a lifestyle center, which is, if you look through my written testimony and most of the examples of eminent domain abuse, that's what these cases involve, is just pure private development takings.
Thank you, sir. Dr. Beito, some of the opponents of this legislation have argued that there's no reason for Congress to step in and try to limit economic development takings, that states already have done enough. How would you respond to such an argument?
Well, again, the example of Alabama, this bill just last month was passed almost unanimously, and it specifically uses the term eminent domain. It gives an eminent domain protection for the automotive industry, I think biotech, several other industries. Now, what's interesting about this is that just after it passed, people were challenged on it, and some of the people who voted for it said, well, we didn't mean to undermine eminent, but maybe our wording was sloppy and maybe we need to do something about it. So this kind of thing, I think, happens a lot in legislative bodies. Bills sort of are pushed through, nobody's really paying attention, and before you know it, it's there. And it stays there, usually, even though we have some regret being expressed. And I suspect this kind of thing happens a lot. So I think this doesn't limit the freedom of states the ability of states to use eminent domain even for private development. All it's saying is we don't want our federal subsidies to go for this, which I think is an important distinction to make.
Well, I thank you all. And